Welcome back. As a 6th degree black belt and barrister, I'm very often asked questions about self-defense, and I hear a lot of myths that I'm going to dispel today. But first of all, if you're just joining our legal community and you've got questions of your own, please do subscribe, hit that like button and the notification bell so that you don't miss out on new videos. So self-defense myths. Lots of little things that lots of you may have heard about, talked about, that may not be quite as they seem. Starting out with the most common that I've heard is someone can carry some kind of weapon for self-defense. The short answer to this is no, you cannot carry something with you for the sole purposes of self-defense. If you want to watch my other video on knives and defensive weapons, I talk about why this is the case. But very briefly, if you carry something with you for the sole purpose of hurting another person, it doesn't matter, in fact, whether it is designed as a weapon or not. You see, there are categories of offensive weapons, and this fits into the third fairly broad category of an offensive weapon. If you take something with you for the sole purpose of using it in self-defense to hurt another person, it becomes an offensive weapon under that interpretation. This would be very different and contrasted, however, if you were being attacked and you reached out to something and then use this thing as some form of a weapon in your self-defense, providing that the force that you used and maybe the thing that you used in self-defense was still reasonable and proportionate force. For example, if you've got somebody pushing and shoving you and you reach for a brick and smash this person with a brick, that's obviously not reasonable or proportionate force in response to your attack. There is another special category of the level of force used for self-defense. It's called the householder case, which I'm going to talk about in another video, so make sure you subscribe for that one. So carrying weapons for the sole purpose of self-defense is potentially going to get you into serious trouble. The next myth that I've heard, which I actually heard for the first time many years ago, but I've heard it more than once since, and this is that if you believe that someone is going to kill you or seriously harm you, that it's okay to hit that person as hard as you possibly can. Now, if you've listened to my explanation of reasonable force in my first self-defense video, this is absolutely not true. You cannot simply say that you used all the force possible just because you thought that the level of force on you was going to be extreme. Now, whilst it is difficult to judge how much force is reasonable in those circumstances, again, if you watch my previous self-defense video, it does come down to what you believed those circumstances were at the time. It isn't for someone else to look back and look at those circumstances as they actually were. It's to look at it as you believe them to be. So was that force reasonable in the circumstances that you genuinely believed them to be? But certainly the idea that you just used as much force as possible is certainly not going to work in many situations. The next myth is that if you were mistaken, that you cannot rely on self-defense. Again, whilst every case is fact-specific, this is broadly not the case either. In 1984, a defendant mistook his victim for being the mugger of a young person. In fact, it turned out that the young person was being apprehended by this victim because the young person had attacked and robbed another woman. So on appeal, this defendant's conviction was quashed on the basis of mistaken belief as to the facts whilst executing self-defense of another person. That leads on to another myth, which is that mistake as to the law provides some other kind of defense. But this is a blanket no. When it comes to criminal law, ignorance is no defense of the law. The next myth is quite a common one, and that is that the defendant must prove that he or she was acting in self-defense. And if you watch my other videos, you'll know that this is not true. The defendant or his representatives need only raise the issue of self-defense and the facts surrounding it. Once self-defense has been raised, the burden shifts immediately back to the prosecution, who must disprove that this person was acting in self-defense to the same criminal standard as the proof of the rest of the prosecution case. In other words, the prosecution must prove beyond all reasonable doubt, or so that a jury is sure, that the defendant was not acting in self-defense, or that the defendant did not use reasonable force. So, for example, if a defendant claims he was acting in self-defense, but the level of force used was so severe that it couldn't possibly have been reasonable, then the prosecution need only prove that the level of force used was not reasonable and so thus doesn't amount to a defense of self-defense. The next myth is to how the defense of self-defense operates. Many people think that self-defense can somehow lower the charge against a defendant. For example, a defendant might be charged with Section 18 or Section 20, which is grievous bodily harm or some serious bodily harm. But if the defendant says, I was acting in self-defense, that somehow this can lower the charge to something like a Section 47, assault occasioning actual bodily harm. But this myth is not true. The defense of self-defense is a complete defense. It's something of an all or nothing defense. If the defendant has raised self-defense, but the prosecution fail to disprove that he was acting in self-defense or using reasonable force, then this would result in an acquittal. It doesn't result in a lower charge. It doesn't result in a lower sentence. It operates as a complete defense. In other words, if the defendant is found by a jury to have been acting in self-defense, therefore using reasonable force, it is a complete defense and he should be acquitted. For example, let's say a defendant is charged with murder and he's raised self-defense as his defense. Let's also say that the jury has accepted that he was acting in self-defense in those circumstances, but they are a little bit unsure as to the level of force he used. Let's now conclude that the jury decide that the level of force he used was not reasonable in those circumstances and he was using excessive force. This means that the defense of self-defense must fail, and it will not result in reducing a murder to a manslaughter conviction, although there may be other grounds such as loss of control or the lack of intent to kill or cause serious bodily harm. Only then would murder possibly be reduced to manslaughter. But in and of itself, the defense of self-defense must fail in those circumstances. Another common myth is that self-defense only applies once you've been hit first. But this is also not true, because you do not have to wait to be hit if you already genuinely believe that you are about to be attacked. This is known as a preemptive strike. There is simply no rule in law that says you have to wait to be hit first in order to defend yourself. But of course, if it turns out that this were not a situation of self-defense and you were in fact the aggressor and that's why you struck first, then you won't be able to rely on self-defense thereafter. Final myth that I've read in lots of your comments is that self-defense cannot be used against a police officer. For example, for a charge of obstructing a police officer under Section 89 of the Police Act. But this is exactly what the courts looked at in 2018. The court held that a defendant may rely upon self-defense or defense of another when answering a charge of assault or obstructing a police officer in his duty. In this case, the claimant believed that his mother was being assaulted by police officers and intervened to protect her. The court held that there were no reasons not to allow this as a general defense in criminal law, just as to any other offense. But remember, you cannot rely on self-defense or defense of another just because you mistakenly believe the arrest to be unlawful. So those are just a few of the myths that I've come across. Do drop your questions and comments down below. Make sure you subscribe and I'll come back to those in future videos. In the meantime, thank you for watching.